Welcome to Hull & Estates and Succession Planning, a series of podcasts hosted by Ian Hull and Suzana popovic-montag that will provide information and insights into estate planning in Canada from the offices of Hull & Hull in Toronto.
Hi, and welcome to Hull & Estate and Succession Planning. You're listening to episode 140 of our podcast on Tuesday, November 25th, 2008. Hi there, Ian.
Hi, Suzana.
How are you today?
I'm terrific.
That's good.
It's a big day today. It's the founder of our firm's birthday.
That's right.
Rodney Hull turns something significantly more than 70. I'm not sure what. And it's a big day for him. So,
congratulations, Rodney.
The topic that we wanted to cover today, and we don't know if we'll get it done in one podcast, so we're happy to do it in two, would interest, I think, a lot of listeners on a couple of levels. So we do remind you that you're free to send some input to us and email us at hullandhull@gmail.com.
Or, of course, feel free to send us an email at estatelaw.hullandhull.com.
All right. So one of the topics that has come up in the past 6 months in our blog, and one that we wanted to sort of flush out a little bit today, was some of our sort of global approach to estate planning and how that dovetails into the different kinds of contentious matters that can arise. And one of the most difficult contentious matters is when you get into a power of attorney fight, when you are fighting over the body, so to speak, while it's alive. Mm-hmm. And when you have a person who's in that gray zone of incapacity, who should control what and so on. So before we get into how that works, let's talk a little bit about sort of our global philosophy that we kind of break down when we think about how we're going to manage people's estate plans. And we've sort of broken it down into three categories. One is of the direct approach, and one is the indirect approach, and the third is sort of a meshing of the two. That's right. So let's start with defining the estate planning process as we have with the indirect. What do we mean by that?
Well, that, Ian, I think is more or less what people would recognize as the traditional way of planning an estate. So it's the documents that you create for instance, in a power of attorney situation, the power of attorney document. If it's a testamentary instrument, a will perhaps, those are the things that we have a comfort level with as lawyers, and probably a lot of lay people as well. Those are those documents that we typically identify with an estate plan. So
we call them indirect because they are people's efforts to estate plan or capacity plan without actually talking to anyone, typically.
That's right.
Because the document does the talking.
That's right.
When you become incapable, the power of attorney does the talking. When you pass away, the will does the talking. And that's not to say that people don't talk about those documents with their beneficiaries and their attorneys before they fall into those categories, those gruesome categories. But that's how we look at indirect. Mm-hmm. All right, so then let's step back again, and if we've got sort of two categories, the indirect, what's the direct estate planning techniques that we have used in the past that are of some help? Well,
those, Ian, are what we sort of call the eyeball effect planning methods. And we talked a little bit during our last podcast about the family meeting, for instance, as a suggestion of a way to do that, where you're actually sitting around a table or in some informal environment with your family members and telling them what your plan is, what you would like to happen if something were to become of your capacity, what you would like to do with your estate upon your death. So you're having that conversation with individuals, you're looking them in the eye, as we say, and explaining to them why you're perhaps treating them differently than they might otherwise have expected. All right, well, for today, and we no doubt will talk in some detail about the family meeting, but we want to remind people that the first probably 30 podcasts of Hull & Estates and Succession Planning really particularize the process in extensive detail. So should they be interested, they've got a resource there. We always like to remind ourselves that we have done some hopefully useful things in the past. That's right. So this indirect approach and the direct approach, these two options, what do we mean by this sort of third hybrid option? What are we talking about in terms of the general concept? Well, both processes, Ian, are so fluid because they really, you can mold them to whatever your particular circumstances are. And so when we say a hybrid, what we're talking about is the fact that some plans will have these kinds of informal arrangements where there's the meeting, there's the discussion, which will then be turned into some kind of document, the traditional kind of estate planning documents that we typically see. And you'll gear your particular circumstances to your situation, and so you'll have maybe a part written, part verbal, part discussion, or whatever it is, and you'll come to something where it's not sort of the cookie cutter expectation of either the direct with the family meeting or ADR, or we call it alternative dispute resolution mechanisms, or the actual traditional documentation.
Okay, so a good illustration that I've seen in the past with the hybrid approaches is that an easy one would be someone does a will, wants to give their gifts to certain individuals in the family, and they tell them that. Mm-hmm. So they tell them who the executor is and who the beneficiaries are. So that A, there's no surprises, and B, that if there's some time to get feedback, they may as well do it while you're alive.
That's right.
So that's our hybrid analysis. Okay, let's spend some time talking about how the indirect, direct, and sometimes hybrid approaches are used sort of, let's put some real tangibles to it, all right? And we talked earlier in this podcast about power of attorney litigation and those kinds of fights. Because there's really capacity planning, which is power of attorneys, and then there's will planning. So let's start with capacity planning and how we can use the indirect and direct form of communication to properly and effectively capacity plan. And let's use one illustration that comes to mind. Let's use the first illustration that comes to mind is choice of attorney. So how are we going to deal with choice of attorney in the two different models?
That's a great setup, Ian, for our discussion. And I think, we start, of course, with an individual saying, or doing the planning, doing the determination of who he or she would ultimately want to take care of their affairs if something were to happen to their faculties and their own ability to do so. And so they will have an individual or two probably in mind, or other family members. They'll call a meeting.
Okay, so sorry, we stopped there. We picked the person,
Right.
all right? So we've done our homework, and that's a personal step that we're going to take with maybe consultation.
Right.
So there is that's indirect because it's ultimately we're not talking to anyone yet, but it might become more direct because we might say, geez, I'm thinking of X, Y, and Z with our friends or our trusted advisors, not our family yet.
Okay.
Okay? So then you're saying we need to call a meeting of some sort.
It's certainly a suggestion in those circumstances. If you do want to steer away from just having it become a surprise at the end of the day, then you'll set up that kind of arrangement where you can have these discussions. And I think it's really important to have them with your proposed attorneys in particular. You want to make sure that they know how it is that you would ultimately like things to be handled once you can no longer handle them yourself, and also consider anyone else who might be affected by that decision, and perhaps consider bringing them into it.
Good. All right. So we're talking now, we're leaving it from just this indirect. It'll pop into the system when I become incapable, and we're bringing in some direct steps.
That's right.
So let's break down those two direct steps. The first is you say we should talk to our attorney. All right. First of all, why would we talk to our attorney? And second of all, what are some of the things that we want to talk to them about?
Well, clearly the fact that you are contemplating them as an attorney would be one of the first things that you'd want to discuss with them, I'd expect. And then beyond that, how you would like them to deal with things, and how you would like them to, for instance, if it's your property that you're dealing with, you'd like your assets managed during your lifetime. If it's your personal care, you would want to discuss what kinds of things are important to you, so that if these decisions have to be made one day, they'll have some ideas as to how you would have liked them to have been executed.
All right. Well, look, I think what we've done is we've started the process of how we're going to use the two communication models, direct and indirect. We're starting to put some illustration to that with the choice of attorney. At the next podcast, let's move on to talking a little bit about, with some particulars, what are some of the actual things we're going to talk about to our attorney before we've come out to them. And once we've decided it, we've done our testing the waters, we come out to them, who we're going to actually, we've chosen the person, who we're going to deal with, and what are some of the issues we want to talk to them about. And we can do that both in indirect ways and in direct ways, and we'll talk a little bit about that in our next podcast. So please, again, we remind remind you that we welcome and look forward to any feedback you may have. Easiest way to do it might be at hullandhull@gmail.com if you're liking the email from that venue.
Or feel free to visit our blog at estatelaw.hullandhull.com.
Thanks, Suzanne.
Thanks, Ian.
You have been listening to Hull on Estates and Succession Planning by Ian Hull and Suzana Popovic-Montag. The podcast you have been listening to has been provided as an information service. It is a summary of current issues in estates and estate planning. It is not legal advice, and you are always reminded to talk with a legal professional regarding your specific circumstance. To listen to other Hull and Estate podcasts or leave any questions or comments, please visit our website at hullastatemediation.com.